Well, welcome everyone. My name is Devin Driscoll. I'm a 2018 graduate of the law school and also co-chair of the law school's Board of Advisors Academic Engagement Committee. Thanks so much for joining us for today's CLE during Spring Alumni Week 2026. One note for folks, a standard CLE credit has been requested from the state of Minnesota, and shortly the number for this program will be put into the chat for you all. Don't worry if you don't see it. There'll also be a follow-up email that will have the code to claim credit as well. Also, we're going to make sure to make time for questions at the end of the panel. If you have questions as we're going, please type them into the Q&A function of the webinar, and I will be monitoring as our presenters are going, and we'll do our best to get as many of your questions in as we can. And with that, let's meet our speakers. So first, Professor Kristen Hickman is the McKnight Presidential Professor in Law, a distinguished McKnight University professor, and the Harlan Albert Rogers Professor of Law at the University of Minnesota Law School. She teaches and writes primarily in the areas of administrative law, tax administration, and statutory interpretation. Her articles on these topics have appeared in Columbia Law Review, Cornell Law Review, Virginia Law Review, and Duke Law Journal, as well as the Minnesota Law Review. Her scholarly work has been cited several times in opinions of the United States Supreme Court. She presently serves as a senior fellow and previously served as a public member and chair of the Judicial Review Committee for the Administrative Conference of the United States. She's also a fellow of the American College of Tax Counsel. Professor Hickman received her JD, magna cum laude, from Northwestern University and clerked for the Honorable David B. Centelli of the United States Court of Appeals for the District of Columbia Circuit before practicing with Skadden Arps. Also, Professor Nicholas Bednar, who is celebrating his 10th reunion this week. Congratulations, Professor. He joined the University of Minnesota Law School faculty in 2023. In March of this year, the university awarded Professor Bednar the McKnight Land Grant Professorship, which is designed to advance the careers of outstanding junior faculty members who've been identified as having the potential to make significant contributions to their departments and to their scholarly fields. He specializes in administrative law, executive branch politics, immigration, and quantitative methods. His research has appeared in the American Political Science Review, Cardozo Law Review, George Washington Law Review, and Political Science Research and Methods, along with the Minnesota Law Review, among many others. He teaches torts and legislation and regulation. Prior to joining the faculty, Professor Bednar received his PhD in political science from Vanderbilt University. He clerked for the Honorable Tracy M. Smith of the Minnesota Court of Appeals and the Honorable John R. Thunheim, class of 1980, of the United States District Court for the District of Minnesota. Professor Bednar graduated magna cum laude from the University of Minnesota Law School, and he served as lead articles editor of Minnesota Law Review, Volume 100. He also received the William B. Lockhart Award for Excellence in Scholarship, Leadership, and Service. He holds a BA in Political Science and History from the University of Minnesota, a double gopher. And with that, I'll turn it over to our speakers.
Welcome, everybody. It's really a delight to be here. I'm super excited to see the names of some of my former students in the list of participants, so welcome. Nick and I are both excited to be here today to talk about learning resources versus Trump, which was recently decided by the Supreme Court in February. Everybody knows it as the Tariffs case. Anyway, I'm going to provide a little bit of background and talk a little bit about some of the opinions before turning things over to Nick. Everybody knows President Trump imposed tariffs upon imports from dozens of countries, including Canada and Mexico, as well as China, based on his own assessment and declaration of national emergencies from trade deficits and from the influx of illegal drugs. He grounded his authority to impose the tariffs in the International Emergency Economic Powers Act, also known as IEEPA. That statute says that when the president identifies an unusual and extraordinary threat to national security, foreign policy, or the economy, originating primarily outside the United States, he can declare a national emergency under the National Emergencies Act. And once the president makes that declaration, IEEPA then authorizes the president to, and I quote, investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, or exercising any right, power, or privilege with respect to, or transactions involving any property in which any foreign country or a national thereof has any interest. That's a lot of words. Drawing from all of those words, the president focused particularly on the words regulate and importation of property, saying that imposing the tariffs fell within the scope of regulating the importation of property as authorized by the statute. The Supreme Court rejected President Trump's interpretation of IEEPA 6-3, but the court completely splintered over the reasoning. We have 7 different opinions across 9 justices, and only a plurality of the justices participated in a key portion of the opinion of the court. 6 justices voted to reject President Trump's interpretation of IEEPA, but 6 justices also rejected applying the major questions doctrine to do so. And in the course of all of these opinions, you do get 6 justices who consider the major questions doctrine as valid, but a different 6 justices from those in the majority. And so we end up with at least 4 and maybe 5 different versions of the major questions doctrine across all of the opinions. So to unpack all of this, I'm going to talk about the opinion for the court by Chief Justice Roberts, and then I will say a few words about the concurring opinion by Justice Jackson and the dissenting opinion by Justice Thomas, both of which were outliers, but also very interesting in different ways. Nick is then going to talk about the concurring opinions by Justices Kagan, Gorsuch, and Barrett, as well as the principal dissent by Justice Kavanaugh, all of which were much more in conversation with one another and with the Chief. So, writing for the court, Chief Justice Roberts offered 2 main reasons for why President Trump misinterpreted IEEPA. He started his analysis with a section on the major questions doctrine, but only Justices Gorsuch and Barrett joined that part of his opinion. And I'll talk about his application of the major questions doctrine in just a minute, because at least to me, that's the most interesting part of the case. Chief Justice Roberts then relied on other traditional tools of statutory interpretation, like dictionary definitions of regulate and considering words in their textual context, to explain why President Trump's interpretation of IEEPA also just wasn't the best reading of the statute. And in addition to Justices Gorsuch and Barrett, Justices Kagan, Sotomayor, and Jackson joined that part of the opinion of the court. I would describe the traditional tools portion of the court's opinion as pretty straightforward and unremarkable, so I'm not going to say very much about it. Like most statutory interpretation cases, it's pretty statute specific. It just involves Chief Justice Roberts walking through a combination of tools and looking at the text of the statute in question. To me, again, the more interesting portion of the opinion of the court was the major questions doctrine discussion. As he's done in past major questions cases, Chief Justice Roberts reiterated his reluctance to find extraordinary delegations of Congress's powers in ambiguous statutory text. He grounded the major questions doctrine in both separation of powers and a practical understanding of legislative intent. In the present case, he further emphasized the core congressional power of the purse as a basis for skepticism that Congress would delegate its taxing authority using ambiguous language. In addition to finding IEEPA's language ambiguous, he cited the failure of presidents to claim such expansive authority in IEEPA's half-century of existence, as well as the astonishing economic and political significance of President Trump's tariffs. Finally, he rejected arguments from the government and from Justice Kavanaugh that the major questions doctrine should have an exception for statutes dealing with emergencies. And in rejecting an emergency statute exception from the major questions doctrine, Chief Justice Roberts quoted Justice Robert Jackson from the famous Youngstown sheet and tube case from 1952, with Justice Jackson observing that emergency powers tend to kindle emergencies. One thing that's very interesting, I think, about Chief Justice Roberts' opinion for the court is that he talked about the major questions doctrine before he talked about other tools of statutory interpretation. You could read that choice in a few different ways. One popular question that I get from students all the time is where the major questions doctrine fits in the full toolbox of interpretive tools when it comes to interpreting statutes. One reading is that Chief Justice Roberts thinks that the major questions doctrine takes precedence over other tools of statutory interpretation. Justice Kagan suggested in her concurrence, as Nick will talk about more, that the court didn't need to talk about the major questions doctrine precisely because other tools of statutory interpretation got a majority of the justices to the same conclusion. The fact that Chief Justice Roberts talked about the major questions doctrine anyway and first suggests that he might think that it's more important than those other tools. But a second possible reason why he might have preferenced the major questions doctrine discussion could have been institutional, to make the point that Chief Justice Roberts sees the major questions doctrine as applying equally to Republican administrations as it does to Democratic administrations, given that the court's relatively recent applications of a more robust major questions doctrine began during the Biden administration. Yet a third possible reason was simply to keep Justices Gorsuch and Barrett on board the opinion of the court, since it was pretty clear that they both saw this as a major questions case and really wanted to talk about the major questions doctrine. We can't really know why Chief Justice Roberts preferenced the major questions discussion before talking about other tools. All we can do is speculate, but those are three possible reasons why he might have done so. Another point that I will make about the major questions doctrine analysis and learning resources is that the court still hasn't given us a whole lot to go on independently, or at least not clearly, about exactly how the major questions doctrine is really supposed to work. The chief in the past has identified various factors as being relevant, including economic and political significance, including the history and breadth of the authority asserted, and including the extent to which the government is relying on modest words, vague terms, or subtle devices instead of direct and explicit delegations. And for the most part, all of those, came into his discussion here as well. But here he also talks about the taxing power as a core Article 1 power that Congress wouldn't delegate without being clear. Some litigants have tried to boil the major questions doctrine down into a fixed set of 3 or 4 requirements. My own sense is that the doctrine is a little more amorphous than that. It's truly, at this point, a multi-factor standard where not all of the factors necessarily have to be present, but more than one of them has to be, and we're still developing the full collection of factors that might be relevant. At a minimum, though, every time we add a new case to the collection of modern major questions decisions, we get more guidance. And so at this point, the best advice I can offer any litigant who is dealing with the major questions doctrine is simply to do their best to synthesize all of these different opinions, which lawyers are taught to do. Now, just to briefly touch on the Jackson and Thomas opinions. Justice Jackson has this interesting little project going of writing concurring opinions in statutory interpretation cases to discuss the relevance of legislative history in interpreting whatever statute is at issue. The late Justice Scalia really led the court away from relying on legislative history as an interpretive tool starting in the 1980s. And it seems pretty clear that Justice Jackson is trying to undo that move, at least to some extent. So far, no one is really joining her in that endeavor. But these methodological moves take time to evolve. So that's just one to watch. Meanwhile, Justice Thomas wrote a solo dissenting opinion in Learning Resources to advance a really novel theory of separation of powers and the non-delegation doctrine. I've been getting questions about this opinion, so let me describe it just briefly. Justice Thomas described the Constitution as vesting Congress not only with core legislative power, which Congress may not delegate to the executive, but also with other kinds of power, which he said Congress may delegate. He offered several examples of core legislative powers, including the commerce power of Article 1, Section 8. Sorry, yeah, Article 1, Section 8, which of course is one of the big ones. But he characterized many of the Article 1, Section 8 powers not as being quintessentially legislative powers, but instead as actual, former, or asserted powers of the Crown, which the drafters decided to allocate to the legislative branch. He then argued that the power to impose duties on imports fell into this latter category of other powers. So Congress, he said, could delegate that power as it chooses. Accordingly, according to Justice Thomas, IEEPA's delegation of the power to impose duties on imports to the president was not only, in his view, clear, satisfying the major questions doctrine, but also constitutional under his theory of separation of powers. And he defended many of Congress's past delegations of power to the president on these grounds as well. Responding to Justice Thomas in his own concurring opinion in Learning Resources, Justice Gorsuch described Justice Thomas's separation of powers analysis as a sweeping theory that would require the court to reimagine much of its case law addressing Article 1's vesting clause and presents difficulties of its own. And that is coming from Justice Gorsuch, who, of course, we all know from the Gundy case, is these days the court's leading proponent for reinvigorating the non-delegation doctrine. So, if not even Justice Gorsuch is on board with this theory, it's really tempting to ignore Justice Thomas's opinion as advancing a fringe theory of separation of powers. But Justice Thomas enjoys a lot of respect among lower court judges as well as academics. And as we all know, with constitutional interpretation, what often seems like a fringe theory and a solo dissent one day becomes prevailing doctrine somewhere down the road. So it's probably best not to ignore this opinion entirely. With that, I'm going to turn over the microphone to my wonderful colleague, Nick Bednar, to talk about the other opinions and their ongoing conversation.
Great. So thank you, Kristen, for the introduction. It's great to see so many of my former classmates and even some of my former students on the CLE. So thank you for joining us today. So I'm going to discuss the concurrences in the Kavanaugh dissent with a specific eye toward how they read the statutory language of IEEPA and what role they view the major questions doctrine as playing in this particular case. So as Kristen mentioned, IEEPA permits the president to, summarizing, regulate importation. That's the operative language we're concerned with in this case. I'll start with Kavanaugh and Kagan, then turn to Gorsuch and Barrett's debate about the major questions doctrine and what the major questions doctrine actually is. So let me start with Kagan. So for her concurrence, Justice Kagan ultimately concludes that the plain meaning of regulate importation does not include the authority to impose tariffs. So according to Kagan, IEEPA says nothing about imposing tariffs or taxes. The text permits the president to regulate the importation of foreign goods. Regulations, however, should not be understood in ordinary meaning to mean taxing. The dictionary definition of regulate is to, quote, subject to governing principles or laws. So Kagan then turns to how other statutes have used regulate in the past, and many other provisions of the law authorize the executive branch to, quote, regulate activities, but these provisions are not understood by either the agency or the president to allow the president to unilaterally levy taxes. The word regulate is like replete throughout the US Code, right? And we don't think the FDA suddenly has authority to tax various drugs and food products simply because its statute occasionally uses the word regulate. So the fact that taxes can be used to regulate behavior, there's no question that we sometimes impose taxes to discourage or sometimes encourage behavior, doesn't mean that the power to regulate is synonymous with the power to tax, according to Kagan. So implicitly, she turns to some other canons of statutory interpretation and applies nociter associis. And you might remember from your legislation and regulation class or the like one credit pass-fail statutory interpretation that many of us were subjected to at some point. Nociter associis means that a word should be interpreted in context of the surrounding words. And so Justice Kagan describes how each word in IEEPA refers to a separate transaction that may be conducted with a foreign good. So Congress specified 99 specific ways that the president may regulate foreign commerce in IEEPA, and none of those ways includes the power to levy taxes. In other statutes, when Congress has wanted to affirmatively give the president authority to levy tariffs, they have used words like duty, tariff, or surcharge. Moreover, it is intended to impose rather significant restrictions on the president's ability to impose tariffs. There are often caps or date restrictions. And IEEPA would swallow those other statutes if it just meant the president could regulate or impose tariffs whenever the president deemed there was a national emergency. So Justice Kagan really just walks through the statute and applies ordinary tools of statutory interpretation to reach this conclusion. And consequently, she doesn't resort to the major questions doctrine. And I think there are really two reasons she's unwilling to resort to the major questions doctrine. The first is that Justice Kagan just opposes the major questions doctrine. Justice Kagan, in other cases, has said that she doesn't think it's a valid principle of interpreting the law. And so accordingly, it's not surprising that she seeks an analysis that avoids applying the doctrine in this case at all, right? Second, Justice Kagan's approach to statutory interpretation kind of follows an approach reminiscent to other justices in applying canons like constitutional avoidance. So in Bond v. United States, for example, Justice Scalia concurred with the majority, but refused to apply the federalism canon, which is often cited as like a quintessential clear statement rule, because the meaning of the act is plain. So Justice Scalia argued that the court must start with the plain and ordinary meaning of the text, not the federalism canon, and therefore the invocation of the federalism canon was not necessary because there was no ambiguity in the statute. The statute was plain on its face. So like Bond, the majority opinion in Learning Resources concluded that the plain text of the statute prohibited the president from imposing tariffs, and Kagan thinks that was enough. You don't have to reach the major questions doctrine issue that Roberts mostly relies on. So Kagan would have rested her analysis on those standard principles of statutory interpretation rather than get to the major questions doctrine. And that tells us something about how Kagan views the major questions doctrine. It is the sort of tool that should be invoked once we have identified a potential ambiguity. But if all of the standard traditional tools of statutory interpretation point in one direction, there's no reason for us to resort to major questions. So Justice Kavanaugh authors the principal dissent. Kristen has already talked about Justice Thomas's dissent on constitutional grounds. I'm going to talk about Kavanaugh's dissent, which is much more focused on the statutory text and the major questions doctrine. So Kavanaugh has two main arguments here. So first, Kavanaugh disagrees with the majority's reading of the statute. So according to Kavanaugh, the statutory text, history, and precedent demonstrate that the phrase regulate importation includes the power to issue tariffs. So one of the greatest pieces of evidence that Kavanaugh brings to bear on this is the fact that President Nixon and President Ford had relied on language in similar statutes to levy tariffs. And Congress enacted IEEPA with these precedents in mind, and therefore would have understood that the power to regulate importation would have included the power for the president to impose tariffs. He also notes there's this long history of presidents imposing tariffs during both wartime and peacetime. The majority, however, counters that none of these tariffs were actually imposed under IEEPA. And that's true. They were imposed under predecessor statutes or statutes that are somewhat more related or distantly related. They all involve other statutes. Okay. Kavanaugh points to the fact that the majority's interpretation permits the president to completely block imports, right? The president can impose an embargo, but argues it wouldn't make sense to exclude the lesser power to impose tariffs. So Kavanaugh asks, textually, if quotas and embargoes are a means to regulate importation, how are tariffs not a means to regulate importation? Nothing in the text supports such an illogical distinction. As a side note, I personally find this to be one of the least compelling arguments that Kavanaugh makes. As a policy matter, there's all sorts of reasons Congress would want to give a lesser to prevent the president from exercising a lesser power. It means the president has to choose between completely restricting all imports or not restricting them at all, right? And so the president is disincentivized to use this power because it's so extraordinary. And so IEEPA could just be acting as a safety valve with strong consequences. It's not intended to allow the president to make minor adjustments to trade policy. It's intended when the president really needs to act in a way to prevent all trade. So moving beyond the plain meaning of the statute, Kavanaugh argues that this isn't actually a major questions case at all. So the major questions doctrine has been typically applied by the court in cases involving extraordinary exercises of power over an area of political or economic significance. So in these past cases, the court has focused on instances where an agency has suddenly seized new powers not previously possessed by the executive branch. So Kavanaugh first notes that this isn't actually an extraordinary case at all. Congress has commonly given the president authority to impose tariffs. And so it's not the sort of unique power that we've seen in other cases. This isn't like West Virginia v. EPA or Biden v. Nebraska, where agencies are suddenly claiming broad sources of administrative power that they had never exercised before. Congress frequently granted the president authority over tariffs. Second, Kavanaugh notes that the Supreme Court has never applied the major questions doctrine in the foreign affairs context. And according to Kavanaugh, because the president wields substantial authority over foreign affairs, the court should interpret the statute as consistent with that authority. Therefore, there are significant reasons not to apply major questions doctrine to foreign affairs cases, at least according to Kavanaugh. So Kavanaugh would create kind of a foreign affairs exception to the major questions doctrine. That said, Kavanaugh also acknowledges that his interpretation of IEEPA is unlikely to prevent the president from imposing tariffs in the future, because there are all sorts of other statutes that authorize the president to impose tariffs. And indeed, that is where we are now. President Trump has imposed additional tariffs using other statutes that have slightly more restrictive language about when that authority can be exercised. So the provision President Trump is relying on allows the president to impose up to a 15% tariff for 150 days. Now notice this section is still more circumscribed than what President Trump sought to do under IEEPA because there's a statutory cap on the tariff and it's time limited for how long the tariff can last. Finally, let me turn to Gorsuch and Barrett. I'm going to talk about these concurrences together because they're really in conversation with one another. It's generally believed that Barrett probably wouldn't have written a concurrence in this case, but for Gorsuch writing a concurrence. And the reason for that is Gorsuch's concurrence is kind of an attack on all of the other justices except the chief. Gorsuch basically says he agrees with the chief and he thinks the chief is doing the right thing, but everyone else has done something horribly and fatally wrong in this case. And so Gorsuch kind of spends his concurrence walking through the flaws of everyone else's approach to this case. And a lot of Gorsuch's dispute here has to do with his specific understanding of the major questions doctrine. So as Kristen said, Justice Gorsuch is perhaps the greatest proponent of reviving the non-delegation doctrine on the court. And it is very clear he has viewed the major questions doctrine as something of a replacement to the non-delegation doctrine. Now, he would definitely revive it if given the opportunity to do so, but he is interpreting and approaching major questions doctrine in a way consistent with his understanding of non-delegation. So in cases involving a major question, Gorsuch demands that the executive branch point to clear statutory authority to sustain an exercise of extraordinary power. Gorsuch's vision of the major questions doctrine is really this sort of refashioned non-delegation doctrine as a clear statement rule, and probably a super strong clear statement rule. Congress has to be extraordinarily clear to give the president or the agency this power. And so Gorsuch is looking for a clear, affirmative, unambiguous statement that Congress wanted the executive branch to answer this major question. Okay, and so he's going to apply the major questions doctrine before he applies anything else. Okay, on the other hand, Barrett offers a much softer version of the major questions doctrine that examines context to determine whether Congress intended the executive branch to exercise extraordinary power. Now, Barrett, as a scholar and as a judge, has been fairly against substantive canons. And so she has not conceived of the major questions doctrine as a substantive canon. She's kind of conceived it as a tool of how we read statutes. It's a textual presumption. Okay, and so she describes her version of major questions doctrine as a common sense principle of communication. And I think the best example of her version of this comes from Biden v. Nebraska, where she offered the example of a parent who gives the babysitter a credit card and tells them, make sure the kids have fun. According to Barrett, a reasonable person would not have understood this command to allow the babysitter to take the kids on a road trip to an amusement park, get a hotel, and let the kids ride roller coasters for 2 weeks, right? There's something about the phrase, make sure the kids have fun, and the context of that command that imposes kind of a common sense limitation on what the babysitter is permitted to do, right? There's actually a really cool law review article that did a bunch of experiments to see whether people think the babysitter actually would be authorized to take kids to an amusement park. The answer the authors of this find is that yes, most people actually think an amusement park would have been a reasonable thing the babysitter could do. The babysitter would not, however, have been permitted to let the kids pet a crocodile, is the other test they do of this. So there is something to this, right? There are like things we intuitively understand would be outside the scope of the command, even if it's maybe they can take the kid to the amusement park. We know they can't let the kid pet the lion, the tiger, or the bear. Okay. So Barrett's vision of the major questions doctrine focuses more on the natural reading of a statute rather than whether it has a clear constitutional or a clear directive to the agency to answer this question. So Barrett believes that contextual clues are sufficient to show that Congress may have intended the agency to exercise a certain degree of power. She doesn't like the substantive canon version that Gorsuch is putting forward. So overall, the opinions tend to suggest that Gorsuch has probably lost his battle for a hyper clear textual or a hyper clear substantive canon approach. The other opinions are looking rather heavily at context in other statutes and surrounding words to determine whether or not Congress authorized the president to impose tariffs. And so, although the chief kind of goes along with Gorsuch's view, it's not entirely clear whether Gorsuch has the support he would need for this hyper clear substantive canon. Of course, there's a whole question here of whether this debate between Gorsuch and Barrett matters at all. Kristen, when she was my mentor and when I was a student, taught me the phrase rearranging the deck chairs on a Titanic, right? At some point, we're just arguing over like semantics, and it's not clear what we're really arguing over, right? The debate is super interesting if you're an academic who really wants to understand the theoretical foundations of the major questions doctrine, and you're trying to figure out where it belongs within the interpretive toolbox. But if you're a litigator, it's not clear to me how much this matters on outcomes. So in terms of case outcomes, it seems like Barrett and Gorsuch will ultimately often reach the same conclusions, right? You can probably find a case where Barrett would say the context shows Congress intended the agency to exercise this power. And Gorsuch would say, no, because we're not going to look at context. We're only going to look at clear language. But that case hasn't presented itself yet. And so it's not clear to what extent this distinction matters if you're actually arguing these major question cases versus if you're an academic who wants to write a bunch of law review articles, in which case it matters a lot. So more often than not, these approaches probably align. And with that, I'll stop so that we can take some questions from Devin in the audience.
Well, thank you both for those great descriptions of the varying opinions. Nick, I'll start with you. Professor Bednar, I'll start with you. Justice Kagan's opinion says that the clear statement rule, apparatus, however we want to describe it, is unnecessary here because ordinary tools help us to help the court to conclude that the government's reading is impermissible. For the circuit courts and for district courts who are trying to hew very close to the mark and not get too far, to be too adventurous, is her concurrence actually the safest roadmap forward for interpreting when there's the possibility of a major question doctrine application or the more general, the more familiar statutory interpretation tools?
Yeah. So in my opinion, I still think Justice Kagan's approach is the safest. Like, I think major questions doctrine is here to stay, and you can't like pretend that it's not a doctrine the courts will ever adopt, because that's not true, right? It's very clear MQD has won the day as a doctrine. But that said, if I were adopting a conservative approach to analyzing a statute, I think I would still start with the ordinary tools that most judges are familiar with, because the prevailing approach of the court seems to be that MQD is just one of the many tools in the interpretive toolbox. It's also one of the hardest tools to apply. As Kristen alluded to, it's still rather amorphous. And Learning Resources tells us a little bit about how the justices might apply this in the future, but it raises ultimately a lot more questions than it answers. And there's still a fair amount of ambiguity there as to how you apply it. Court first needs to decide, is this even a major questions case at all? And then if it is, has the agency or has Congress spoken clearly to give the agency the power? And so this two-step framework is still a little difficult to apply. And I think a lower court judge would be better off starting with those ordinary tools if those ordinary tools are going to point in one direction. When the ordinary tools of interpretation, such as dictionaries, language, textual canons, all point in the same direction, you don't need MQD at all, right? So I agree with Kagan that traditional tools just lead to a plain reading here that excludes tariffs from one of the tools conferred by IEEPA. Word regulate hasn't been historically understood to include taxation in the ordinary sense. When Congress has intended for the president to impose tariffs, it is spoken clearly in other statutes. There's no reason to read the statute here as permitting tariffs, given all this context. I think the harder cases are those cases when the traditional tools diverge from one another and applying different canons leads to different results. And I think that's where you should have courts starting to engage with MQD. But I would exhaust those traditional tools first.
And I
I
wasn't planning that.
generally agree with Nick on this. However, I want to caution everybody against turning the major questions doctrine into the new Chevron by requiring a finding of ambiguity before you turn using traditional tools before you turn to the major questions doctrine. And I'm sorry, Devin, I interrupted you.
No, not at all. I was just gonna ask Professor Bednar. He had framed that from the court's perspective. I'm a litigator. For my fellow litigators on the call, from a litigator standpoint, did learning resources actually make the major questions doctrine more predictable, less predictable? How should folks before the courts be thinking about raising the major questions doctrine for the court to consider?
I'll let Kristen opine after because she might have far more sophisticated thoughts on this matter than I do. I don't think it made it more predictable at all, in part because you actually don't have a majority joining the major questions portion here, right? And there are all these weird carve-outs that a bunch of the judges or justices want. Like, you still have this whole question about, like, are emergency statutes ever exempt? The chief seems to say no. There's this foreign affairs exception that Kavanaugh's raising. The chief says no, but, like, again, you don't have full support for either of these positions. There's this whole Barrett-Gorsuch understanding. So, I think if you're a litigator, no, this case didn't really clarify anything. It's like a wonderful teaching case. Like, I will teach this in legislation and regulation because the debates really allow you to engage with what this doctrine is, but it's a super frustrating case if you are being asked to apply this to a client-specific situation. I mean, I think the answer, if you're a litigator, is like, you better be exhausting all the ordinary tools, plus also including a major questions analysis, if you think this is one of those cases that might reach that threshold, right? But I'll let Kristen probably has more sophisticated thoughts, so I'll let her.
I don't know about more sophisticated. I think the one thing I will pick up on is that last little if that you threw in there, Nick. One thing I have seen is an awful lot of cases where there's not a chance in the world that the case is a major questions case, and yet litigants have felt the need to throw in a major questions argument. Kind of like if you're a criminal defense attorney, you're going to throw in the rule of lenity, because why not? Why not throw in a major questions argument? And all of that's fine. But I think one of the things that seems very clear to me is that just mentioning the words major questions doesn't get you very far. When you have this much discussion and disagreement among the justices about even what the major questions doctrine is, I think that if you're going to make a major questions argument, you really need to make a major questions argument in a serious and thoughtful sort of a way. And it's just not worth, my guess is, putting in that kind of time and effort to the major questions discussion unless you feel pretty strongly that, in fact, this is a major question sort of a case. And one observation that I have made about all of these major questions cases is that they tend to seem to be sort of the front page New York Times, Washington Post kinds of agency or government actions where the court is raising them, vaccine mandates and, the tariffs and things like, student loans, those kinds of things. That seems to be the sort of case when they come up. It's not enough that you're talking about a matter of economic significance, for example. You need more. But that then gets us into which more? Which factors do we pay attention to? So, if you're going to make a major questions doctrine argument, I'm just saying really make the argument and engage with the discussion. And that to me counsels against throwing it into every single brief involving a statutory interpretation question.
Professor Hickman, I'll certainly say that in my area of environmental litigation, we are starting to see more and more major questions doctrine pieces sort of just cut and paste um, uh, in part because of the scope of the economics and not necessarily, as you say, about like whether it's one of those front page
Sure.
issues. So it'll be interesting to see as that develops. Say, Professor Bednar raised the both Chief Justice Roberts' discussion about the no emergency powers or for an exception, foreign affairs exception to the major question doctrine. And then Justice Kavanaugh saying foreign affairs statutes are different and major questions doctrine may not apply with the same force. Which of those positions should we, government lawyers, private counsel, others, be thinking lower courts are going to want to develop more, do you think?
That's a really tough question. First of all, I think it's probably not one that's going to come up all that often because let's face it, most of the statutory interpretation cases where major questions is coming up don't involve emergency powers or foreign affairs. Um, at this point, you've got three justices one way and three justices the other, and I believe three justices who are silent, which makes it pretty tricky, right? Um, although the ones who are silent aren't fans of the major questions doctrine. I suppose there's an extent to which I would say, unless you are, given the lineup here, unless you are a particularly eager lower court judge to push that, aggressively for some reason, or unless you are a particularly desperate litigant who doesn't have any other argument, I would be inclined to suggest that there probably isn't going to be an emergency powers or foreign affairs exception because I think Chief Justice Roberts is right that it could be too easy for those to be the sorts of exceptions where you could frame it in such a way that the exception swallows the rule, right?
I, I'm gonna this is my time for a hot take. So I actually think so first, let me establish my position here. I don't like the major questions doctrine. So acknowledge that that's on the table, right? I actually think if you think theoretically about the major questions doctrine and what it is doing, an emergency exception actually makes some degree of sense. Because the major questions doctrine is founded on the idea, to some extent, that Congress could not have intended the agency or the executive branch to have exercised this large economic or political power. It couldn't have foreseen the agency would have done this. But there are two issues with that in the emergency delegation standpoint. One, the reason we have emergency delegations is it's because Congress can't foresee that some big thing is going to happen, and it has the emergency statutes in order to have this safety valve when there are major political or economic problems that emerge so the agency can quickly react to them faster than Congress can. So I actually think the major questions of doctrine shouldn't necessarily apply to emergency statutes. Now, I think the big hiccup here for me is that the courts typically won't question the president's determination of whether there's an emergency. And so you get back to what Kristen said earlier about, Justice Jackson's quote from Youngstown Sheet and Tube that's like emergency delegations just tend to lead to more emergencies. And maybe that's true, but maybe if we were stricter about when an emergency can be revoked or invoked, we get to, you know, easier delegation here. Minnesota Law Review published last year a note from one of my former students entirely about whether the major questions doctrine should be or should have an emergency exception. And so I invite you all to go look it up because it's a great note. Mark Hager wrote it.
And you can find it on minnesotalawreview.org, I suspect.
Sponsored by.
So let me ask this then, Professor Hickman. You noted at the very top, it's a fractured opinion. We hear the justices are talking among themselves as much as giving guidance. Obviously there's the binding effect on the parties from the judgment in this case. But what actually is the result? What is actually the rule that's coming out of this? What is the controlling proposition that is coming out of learning resources?
I mean, I think because the court is so fractured, really the main thing you pull out of the case is the interpretation of IEEPA. We've got the interpretation of the statute. How the court got there, is all over the map. So in terms of binding principle, I think that's really pretty much all you've got. That doesn't mean that learning resources, I think, is a case that we just set aside because it's so fractured, precisely because I do think that the court's ongoing discussions about the major questions doctrine have broader implications, even if they are fractured. It's just worthwhile to try to familiarize yourself with the arguments and with the different versions of it. On the one hand, Nick is absolutely right. In most cases, I think you're going to see, for example, alignment between Justices Gorsuch and Barrett, or alignment among the six justices who believe in the major questions doctrine as to whether it applies or not. But there are those marginal cases where you are going to get disagreement. And so, that's where the nuances come into play and could be potentially relevant. And I will also say, again, as much as tempting as it is to treat both Justice Thomas and Justice Jackson's opinions as outliers because they seem to be talking about something else than what the other justices are talking about, they both reflect smart justices trying to advance arguments that could, down the road, gain more adherence and greater salience. So this is one where the power of the decision is not in the binding part of the holding, which seems to be pretty narrow, just dealing with IEEPA, but rather the different, more theoretical ideas that are being advanced and whether and to what extent those different ideas are going to emerge as having more power in future cases, such that we look back at learning resources and say, okay, this is where some of this is coming from. Like some people have suggested, for example, that the collection of opinions here, and particularly Chief Justice Roberts's opinion, seem to be leading the court more toward Justice Barrett's text in context sort of approach to major questions rather than Justice Gorsuch's super clear statement requirement. Nick suggested as much in his opening presentation, and I think that I've heard that suggestion made by a lot of different people.
So, Professor Hickman, if the interpretation of IEEPA is the main holding here, what could Congress do? Let's say that Congress actually did want to enact genuine emergency trade authority of the type that the administration was claiming. What would the kind of careful drafting, based on what the court is saying, require of Congress to actually give that authority to the administration?
I think they, after this opinion, to some extent, Chief Justice Roberts has just given them the roadmap by saying, okay, you've got to say expressly that you are delegating this power to tax, this power to impose tariffs, by name. As Nick mentioned, other statutes had talked about tariffs. And so just be more explicit about that. And that's dissatisfying in some ways because it's always easy to just sort of say, oh, Congress should just be clearer. And there's no way that that's going to happen, right? Congress, no matter how clear they try to be, there's always going to be some case that comes up that raises some ambiguity in whatever language Congress uses. But I mean, and this is where the emphasis on the core Article 1 powers is kind of interesting. If Congress is dealing with, whether we're talking about tariffs and taxes or some other core Article 1 power, you know, being at least a little bit explicit, core legislative power, being a little bit more explicit in those circumstances, I think is what makes some sense. Rather than just sort of saying reflexively, Congress should be clearer in all cases.
I want to just add one thing to that. That's like a slight aside, but something I think is worth pointing out, which is the Supreme Court has never actually found a clear authorization when there's a major questions case, right? So there's a major, like the court determines there's a major question and has never found that the agency is clearly authorized to do it. And so there is a question that is lurking back here about these cases that involve perhaps unconstitutional delegations of legislative or taxing power, whether the court would then take the bite out of the apple to bring the non-delegation doctrine or the taxing power in. And I don't know that it would.
So, Nick, do you not see King versus Burwell as a major questions instance in which the court decided that Congress did, I mean, it didn't say that Congress delegated the power to the agency, I guess. It said the statute was clear that Congress intended the agency to be able to do what they did.
So that's how I would distinguish King v. Burwell. Is King v. Burwell isn't the statutory text is clear, but it's not clear because the agency had authority to decide the question. It's Congress decided the question. And it's just the structure.
It just happened to be what the agency did. For those who don't remember, King versus Burwell was the case under the Affordable Care Act around about 2016 or so, where dealing with whether the IRS's decision that if a state didn't create a healthcare exchange for selling policies, the federal government could do it on behalf of the states. And the IRS claimed that power. And Chief Justice Roberts, writing for the court, said this is a major questions case, not quite using the major questions label, but nevertheless, otherwise reflecting the doctrine. And so Chevron didn't apply. This was back when major questions was part of the Chevron analysis. And so the court went on to interpret the statute for itself and decided the IRS got the interpretation of the statute right, that the statute was clear.
Well, we've come, unfortunately, to the end of our time. Thank you for a fantastic discussion, Professor Hickman and Professor Bednar. When we get back together for Professor Bednar's 15-year reunion in 5 years, it'll be interesting to see whether we think of learning resources as an Article 1 core legislative powers case, as a major questions case or what that conversation has been doing. I look forward to continuing that conversation. Thank you all for joining us today and for our speakers on sharing their expertise with us. We look forward to seeing you for the rest of Alumni Week this week. Take care.
Thanks so much,
Devin.
Devin.